let's wait and just let everyone get settled. Okay, Mr. Trowbridge, and to the extent that you can, even if you're referring to other materials, try to be on the middle part of the podium.
Yes, Your Honor. May it please the court. This case should not have been decided on summary judgment. In this case, Your Honors, the ultimate issues depended on the consideration of multiple acts of omission and commission that took place over a period of months. Those acts and omissions took place by both parties, MCM and Legend Bank, and where, as here, the parties submit substantial and detailed evidence and reasonable minds could have differed on the levels of responsibilities those parties should bear, then this case should have gone to a jury and it should not have been decided by summary judgment. It was error that it was done so. This case is like this court's decision in Bank of Saipan versus CNG Financial Corp, where the case turns on the totality of the evidence.
So is this jury argument your strongest argument? Are you giving up your argument about unjust enrichment being a separate cause of action?
No, Your Honor.
What do we do with the language in this court's 2020 decision where it stated at page 251 of the federal appendix, quote, "We have now affirmed the dismissal of the fraudulent transfer claim and only reinstate MCM's money had and received claim," end quote. Isn't only language of exclusion?
No, Your Honor, because another area in the order said that the section of this was in the section of the court's opinion titled "Money Had and Received and Unjust Enrichment." That was on pages 245 to 247, and that ended with the statement, "These claims," plural, "are reinstated and remanded." Thus, the court remanded 2 claims.
But wasn't the court treating unjust enrichment as essentially a claim for a remedy? In your own complaint included certain counts that were entirely remedial, punitive damages. You had a count for punitive damages. Wasn't the court just mimicking your own language and referring to unjust enrichment as a claim in the sense of a claim for a remedy, but not a independent cause of action?
No, Your Honor. Both money had and received and unjust enrichment are legal claims. They both touch on equity, though. So in fashioning a remedy, a court will consider equitable principles in deciding both money had and received and unjust enrichment. But because they are legal claims, the Seventh Amendment guarantees litigants a right to a jury in all suits at common law. Money had and received is a legal claim. Unjust enrichment is also a legal claim. The claim is legal even though it's controlled by principles of equity. That was stated by this court in Bank of Saipan. Unjust enrichment is where a party seeks a judgment for money damages. That likewise has its origin in courts of law. So they're 2 separate claims. They are different. I would say the main difference between the 2 is that unjust enrichment depends on wrongdoing in some form, whether it's form of fraud, duress, or taking of an undue advantage, and that can be by the defendant or it can be by a third party, whereas money had and received does not depend on a wrongdoing. So the parties are different, they're distinct, and this court remanded both of those claims back to the district court.
Has there been any Texas state court case that has recognized both a money had and received cause of action and an unjust enrichment cause of action as distinct in the one same case?
I would point to, yes, Your Honor. So Best Buy Company Incorporated versus Barrera explained the distinction between the 2. Also, City of Harker Heights, Texas versus Sun Meadows Land. That one distinguished them by saying one had its origins in common law, the other in equity. And I believe this court, applying Texas law, also treated them as distinct. much like Clapper versus American Realty Investors Incorporated, stated that the two are not the same. Clapper, now that was a Northern District of Texas federal court case, but it was applying Texas law, and that stated unjust enrichment and money had and received, while conceptually related, are not synonymous. And that's what you'll see in most of the cases where there's money had and received and unjust enrichment, is a statement to that tune, that they are conceptually related. They have some equitable considerations that go in, but they're claims at law, they're legal claims, and they're not the same.
Why were you distinguishing so heavily between use of unclean hands as an affirmative defense versus conceiving of it as simply one among the equitable factors that goes to the merits of your money had and received claim, given that money had and received turns essentially on good conscience, right? That's the standard, in fairness and good conscience. So why wouldn't unclean hands just be one of the considerations that goes to what a jury could find about good conscience?
Because this court concluded in its the first opinion out of the first appeal that unclean hands is akin to comparative negligence. And therefore, yes, I'd say we're both right. It's treated as an affirmative defense, but it really goes to balancing the comparison bad behavior, so to speak. And that's what the district court did not do, and that was error. So what the district court, how they erred, is because the district court granted Legend Bank judgment as a matter of law on the money had and received claim on the basis of unclean hands. But this court in Banc of Saipan said a defense of unclean hands is inherently fact sensitive. You have to look at everything that the victim, the person saying, you have my money, did, but then you have to compare that to, well, what did the defendant do, if anything?
You're not suggesting that it's never capable of summary judgment.
Pardon?
You're not suggesting that these types of very fact-sensitive, intensive claims are never subject to summary judgment.
If I would
We do
say
summary judgment all the time on cases that are fact-intensive.
this, I would say it'd be rare that an unclean hands defense could be decided on summary judgment because it's inherent to looking at equities, balancing equities, and that's not proper on summary judgment. You know, if you look at what was done here, they looked at, basically the judge was looking at credibility determinations, weighing of the evidence, balancing.
But your client knew, of course, of Mr. Lyon's past history.
As did the bank.
Right, understood. And well, although as I understand it, the bank did not know that Mr. Lyon had anything to do with these accounts. Am I mistaken about that?
No, that the summary judgment was contrary to that. If you look at, and it's detailed in the record, but the evidence showed that the bank, Legend Bank, knew that the Lyon son Tony worked with their cattle business. That's in the record at 7265 and 8552. The summary judgment evidence showed that Legend officers also knew that Tony Lyon had a criminal conviction for providing false statements to a bank in 2002. The summary judge in that record site was 7192 through 7196, 8579 to 8580, and 8778 to 8779. But also, the summary judgment showed that the bank president, Brennan, and Tony Lyon called and texted each other often. And usually those calls and texts coincided with the critical events that were laid out in the check-kiting scheme.
What I'm waiting to hear, and I have not heard yet, is that Legend knew that Mr. Lyon had access to the parent's account. Is there evidence of that?
Yes, there's evidence that employees at Legend knew to reach out to Tony with issues concerning the Lyons account. Now that may be slightly different than what you're asking, but it's pretty close. They knew, and in fact, not only one person knew. Brennan was the bank president, but he also notified Jay Bearden, that's the chief lending officer, so higher than the bank president, about Tony's involvement with the parent's cattle business.
With the
that's in-
business or with the checking account held with Legend Bank? So I do think there's at least a gap there.
Well, I would say what I said earlier, that if you're asking, did the bank know that Tony Lyon had, let's say, access to the parent's checking account? I would say what the summary judgment showed was that the son, Tony Lyon, was contacted on the checking account. So that was who the bank was communicating with.
Let's shift then, fair enough, good points. Let's shift to your client's series of conduct. I get your point that both MCM and Legend knew about the criminal history, hoped that Mr. Lyon had sort of moved past that history. Do I understand correctly that your client also had a series of red flags and sought to meet this hypothetical buyer and was never given that opportunity and then decided to ignore those red flags?
Yes, there was evidence of red flags on both sides of the aisle, Your Honor. There was evidence of red flags on Midwestern Cattle, MCM side, and there were numerous red flags on Legend Bank's side. I mean, the most egregious were the fact that the alarm system at the bank was going off every day. We detailed in the record and at summary judgment that the Lyon account showed up on Legend's suspect kiting report. It was a list generated every day, and it showed up on that report for 113 consecutive days. In addition, the account set off red flags in the tune of fraud alerts, literally an alert that came out at the bank that it generated 21 separate fraud alerts. And in fact, the evidence showed that the account was generating so many fraud alerts that the bank employees turned off the fraud alerts, said there's too many going on here. Last on that point, Legend's own red flag system, their internal system, generated 61 overdraft notices in 6 months. 61 notices in 6 months, including 29 of those that were over $1 million.
Okay, so how does unclean hands work when both sides had fair warning? Why should we then tip the scales, given that both sides hypothetically are I don't want to say culpable, but equally had opportunity to find the problems?
Yes.
Why should that tip the scale towards a jury trial rather than no remedy to your client?
The reason, so it works in that both sides are able to present evidence in that the defendant in a money had and received claim can present any facts or raise any defenses that would deny a plaintiff's right or show that the plaintiff should not recover. And I point you to in that, let's look at just the simple elements of a money had and received claim. The plaintiff has to show that the defendant holds money, that the money in equity and good conscience belongs to the plaintiff. Okay, so you're looking at equity and good conscience in this analysis. So if the defendant can say, here's a fact or here's a defense that shows why the money doesn't belong to the claimant in equity or good conscience. Well, the necessary corollary to that rule is that the plaintiff then can meet that defendant's denial with facts that establish the right to recovery. And that's really what the Banc of Saipan talked about, that decision. And here's how to directly address your question, here's how it should have worked.
Banc of Saipan, in fairness, was a little different, right? Didn't Banc of Saipan have a defendant, I think it was the defendant, who was not only had red flags, but then decided to actually try to take advantage of the situation?
There was evidence of that, and there's evidence in this case as well, Your Honor. You'll see in the record that the president, Brennan Williams, was engaged in for-profit cattle transactions with Tony Lyon, the fraudster. And when he first testified about that, he disavowed and said he didn't have a relationship with the Lyons or Tony Lyon. Then later, he changed his testimony. And thus, we detail in our brief how that perjury is allowed to be considered by a jury in determining credibility issues. And that didn't happen here. Another case, in addition to Banc of Saipan, that this court could look to for guidance is the Fifth Circuit's recent case in matter of Okidokin, where that's a good example, Your Honor, of how the balancing of equities took place with an unclean hands defense and a money hadn't received claim. That involved a bankruptcy court. So there, the judge was serving as a trier of fact, but it wasn't a summary judgment. In that case, in Okidokin, they conducted a multi-day trial. In the district court, the bankruptcy judge issued a 176-page memorandum opinion containing a detailed analysis weighing the equities after a trial with evidence. Compare that to the 6-page order that the district court issued here after considering only affidavits on summary judgment. If the court did engage in a balancing of equities at summary judgment level, that is a violation of Anderson versus Liberty Lobby, which says cases should not be trial by affidavit. I'm out of time.
Yes, your initial time has expired. You've saved time for rebuttal. Thank you.
Yes, Your Honor.
Mr. Kirkman?
May it please this court. I think it is critical that we focus on what exactly happened and what the issue is before this court. With all due respect to my very able counsel, it is my belief that he is attempting to relitigate matters that have already been before another panel in this court that are the subject of another opinion. The question that was remanded by this court to Judge McBride was the money had and received claim to determine whether, in fact, constructive trust remedy might be appropriate. That is what this Fifth Circuit Court did. Now, on the question of whether there is a separate doctrine of unjust enrichment as opposed to money had and received, I must point the court to a very recent opinion of the Fifth Circuit that I think nails that position in a practical matter. The L-Bar decision that, in fact, Mr. Trowbridge cited to the court in his post-submission briefing does specifically state, Your Honor, that Texas courts are divided on whether unjust enrichment is recognized as an independent cause of action or is merely recognized as a contractual theory of recovery. That's the Fifth Circuit statement. However, what is critical in this case is the Fifth Circuit went on and said, regardless of that distinction, and I respectfully submit that that is a distinction in this case without a difference, regardless of that distinction, a plaintiff can only recover when one person has obtained benefit from another by fraud, duress, or the taking of an undue advantage. I also want the court to remember that the Fifth Circuit has already stated in its opinion, which is the law of the case, that to dismiss a money had received claim under an affirmative hands defense, the court should balance the plaintiff's errors of omission and commission against the defendant's unjust acts. Now, this court has already stated...
Counsel, can I read you a quotation? Can I read you a quotation from this court's opinion in the first appeal and tell me which specific part of it you're taking issue with, if any?
Sure.
In the first appeal, the court's opinion stated that, quote, when the defense, the unclean hands defense. When the unclean... This is a quote from the court's opinion in the first appeal. When the unclean hands defense, quote, sounds in negligence, the issues of the plaintiff's negligence and how much it offsets the defendant's conduct raise fact issues usually appropriate for a jury, end quote.
Yes.
That would seem to be law of the case. Are you disagreeing with that? Or are you just saying that the usually caveat is not applicable here, or does apply here as a caveat?
Two things. Emphasis on the word usually. Actually, three things. Emphasis on the word usually. Number two, this Fifth Circuit's clear statement that this is an abuse of discretion standard in determining the efficacy of the money had and received claim. And three, the facts that are before this court are undisputed. The facts that the judge relied on in making his discretionary decision of whether to apply the money had and received claim are really undisputed.
Some of them, right? Yes, maybe who made a phone call at what time is undisputed, but your opposing counsel is arguing those facts support further factual inferences about what the Legend Bank president knew, branch president knew, and those facts that could be inferred are disputed, correct?
Well, that I really don't believe so. And here's the reason, Judge. We have already litigated the underlying questions of duty, negligence, and all those other aspects of what he's trying to say this bank, which was unaffiliated, completely unaffiliated with MCM, had. This court held there is no such duty that this bank owes to this unaffiliated cattle broker. Now that's number one, that's been decided. So second of all, when this court said you need to balance the equities, Judge McBride, you need to take a look at, and I think the quote is, whether the sins of the plaintiff, which it further defines as errors of omission and commission, outweigh or balanced against the defendant's, and here's a terribly important quote, Judge, unjust acts or unconscionable. Those are equitable principles. This is not a case where you try a negligence duty to a jury and he puts a bunch of evidence out there about what the bank did and that's bad and that's bad. This decision has already been made on the question of whether there's a duty owed. What this court did in this previous opinion is told Judge McBride, weigh the equities, balance the equities. Don't have another wide open jury trial on questions we've already decided. Take a look and see whether the sins of omission and commission outweigh the unjust acts. And unjust acts is a clear, very important piece of the analysis. And I submit to this court that when you do that, as Judge McBride did in his opinion, you can only determine that under his discretion, and again, Judge, this Fifth Circuit has already said this is an abuse of discretion case. They went to great lengths in their opinion in stating, I think it's footnote 19 if I'm not mistaken. No, 15, I'm sorry, 15, where they talked about this is the standard for us to judge, an abuse of discretion standard. When you take that abuse of discretion standard guidance that this court gave Judge McBride, and you look at the way he analyzed it, I don't think there's any question that there cannot be an abuse of discretion.
So what is your theory for, in the unclean hands defense, what is your theory for what is for the jury and what is for the judge?
Well, I think what the court remanded back to the judge was for the judge to determine.
If you don't mind, what is for the jury to decide? What is for the judge to decide?
Well, an abuse of discretion and definition of balancing of equities is for a court to decide. Now, if there's a factual dispute,
is your theory? I'm not sure I got my answer. Is your theory that the jury decides if one side has, if either side engaged in any sort of misconduct or had any red flags they ignored, but it's for the judge to decide how to balance those two things?
Well, it's certainly the latter. I do not believe it's...
Okay, but doesn't that directly contradict the passage that Judge Barker just read? The issues of negligence and how much it offsets the defendant's conduct, both of those things raise fact issues usually appropriate for the jury.
Well, you've got to square...
My instinct might have been yours, except that I'm reading that our opinion is quite different.
But you have to square that with the language of what the Fifth Circuit said. You got to balance against unjust acts. It's just not a free-for-all to say, well, you know, the bank didn't do this and the bank didn't have this alert. And that. It's not a free-for-all. That issue on the question of duty of negligence has already been decided. He's got to weigh those factors in terms of an unjust act. Now, if he believes there's evidence that conflicts onto balancing those equities, Your Honor, then he can submit it to a jury. But he clearly did not believe any such evidence, conflicting evidence existed on the question of defendant's it's unjust to the defendant, unconscionable. That's what the law requires this court to do in deciding whether to balance those equities. When you consider, undisputed judges, Tony Lyon was a convicted felon. He was convicted of bank fraud. He was convicted of bank fraud in the cattle business. He gave his checkbook and signature stamp to, the MCM gave it to Tony Lyon. There were 136 transactions. The MCM never even saw one head of cattle. It went on for 5 months. Significant money was paid. Never even met John George. And the suspicions of Tom, the partner of Jason under MCM, that this was a complete fraud, incredibly outweigh the balances of any unjust act.
What is the evidence in this case that Legend Bank may have taken advantage of the situation?
But Legend what?
Legend Bank, or at least one of its employees, may have taken advantage of the situation, these sort of other cattle deals.
The Fifth Circuit specifically held on, as we quote on page 9 of our brief, that Legend did not assist or conspire with Tony in devising and executing the scheme. It determined that Legend was not aware that Tony had access to the Lyon account, that he was using, or that he was using it for fraudulent purposes, or that Tony was defrauding MCM. Those are established law of the case. My esteemed counsel wants to relitigate those. Those have already been decided by the Fifth Circuit. And keep in mind, that was through a substituted opinion that this court wrote to make dead certain and clear that those issues are decided. They also held Legend did not know that Tony had check writing control over the Lyon account or MCM's Points West account in Nebraska, or that MCM provided its checkbook and signature stamp to Tony, and that Legend understood the activity in the Lyon account was due to business dealings with MCM. All of those are cited in our brief in the record, and that is what the Fifth Circuit already held. And again, at the risk of me repeating myself, what MCM wants to do is relitigate those. And that is not the spirit of what the Fifth Circuit did when it remanded this case for the balancing of equities to Judge McBride.
Well, I'm not sure, because I definitely see the passages, I'm not sure. I see the passage you're talking about in the facts section of our earlier opinion. No evidence, no evidence. Got it. But I also see, obviously, the remand language sending these issues usually to a jury. If if MCM, you're a Legend, if MCM thinks that we're wrong, that there is in fact evidence, why doesn't our opinion essentially let them send that to the district court on remand?
Because number one, that is relitigating the duty question that the court has already decided. In my judgment, doing that is going beyond the spirit of what's remanded. You're essentially you're allowing MCM to retry its negligence case in the context of an unjust enrichment money hadn't received claim, and they are just two different animals. You've got to have unjust, unconscionable result. And Judge, I also want to keep in mind that on appeal, the only real issues that MCM has raised with regard to these payments are 4 money transactions that they described paying. Actually, it's 3. There were 4 that were decided by Judge McBride, and they did not appeal the cattle sales.
Mr. Kirkman, unless it's stepping on any toes, before you get into those 4 specifics, may I ask about another passage from the Fifth Circuit's first opinion, this court's first opinion, where in addressing the issue of the banking industry experts, this court at page 251 wrote that it is necessary for the district court, to consider whether these experts could help a fact finder decide the money had and received claim. Doesn't that indicate this court was contemplating that some aspects of the money had and received claim were for a fact finder? In this case, a jury, because the plaintiff demanded a jury trial?
I don't believe so. And remember what Judge McBride did is he said in his characteristic way, as the judge, I don't need that to decide a money had and received claim. The Fifth Circuit didn't say you've got to. It said he should consider. Isn't that what a district judge is supposed to do, is consider that? He did that. He specifically addressed it and said, I don't need an expert opinion.
Right, but what he was supposed to consider was whether the experts could help a fact finder decide the money had and received claim. Now, of course, he could say no, or he could say there's no material dispute that should go to a fact finder, and then that could be appealed, and maybe that would be upheld. But doesn't that language at least indicate that this court ruled some aspect of the money had and received claim to be for a fact finder?
I don't believe so. And again, whether a particular expert can testify on a particular issue is a gatekeeper judge function. And Judge McBride specifically said, in the context of what I've been asked to do, there's no need for an expert testimony on these issues that he went through. And it makes complete sense to me when this court has already said this is an abuse of discretion standard. Judge McBride, you got to weigh the equities. He's done that. And when all this cattle broker is trying to do is dig up and regenerate issues and facts that have already been decided against it. With all due respect, this is nothing but a backdoor attempt to try the negligence claim. It really is.
Counsel, I hear you defending the order as a proper exercise of an equitable judgment assigned to the district judge. Assume that the court now were to find that there is a fact issue. Are you prepared to defend the order in the alternative as a proper grant of summary judgment, bypassing a trial on those fact issues?
On the question that was remanded, money had and received, absolutely. And again, I know I'm repeating myself, but this is not a negligence case. That issue's already been decided. The fact issues have to be relevant to what the law says is relevant in a money had and received unjust enrichment claim. And you've got to find sins of omission and commission versus an unconscionable result or unjust acts. You will find that language nowhere in a negligence case. Nowhere do we have to sit through this evidence, well, the bank did this, the bank did that. That's not an unconscionable manner and means by which to hold money. And judges, I also want to point out what is a very practical aspect of this. This is a check-kiting case. This is not a situation where I give money to Joe Blow by mistake and Joe Blow has the money and you have money had and received, he's unjustly enriched because he wasn't entitled to this money. The bank never held the money. Keep in mind that every transaction that was associated with their claims, the money went to MCM. And I cannot state any clearer the factual analysis of this $4,300,000 so-called payment that MCM raises as one of the issues to go that they say should go to a jury. On page 3 of Judge McBride's opinion, he sets out specifically all the relevant facts that are related to that. I can't add to that. There's nothing that is more relevant. There's nothing else relevant. Those are the specific facts. And when this court takes those facts and reads that first full paragraph on page 3, I don't know how they can possibly come to a conclusion other than how in the world there's a claim that the bank holds the money. There can't possibly be that. Plus this $4,425 number, if I've got the number right, that is relied upon by MCM in its claim, is nothing but a bookkeeping entry. It's not a payment, it's a check. I mean, a check was presented, the bank held it. When in customary practice, once money was received, they credited it. It's a very simple factual analysis. That is not unconscionable. It is not unjust. Particularly, Your Honor, when considering any alleged factual dispute that surrounds the question of money had and received. We followed the UCC. This court held. The final payment rule was followed. We did whatever we were supposed to do in the context of the UCC law with regard to that payment. Now, when you put that in a negligence context, as Midwestern Cattle tried to do in the first case, they argued, well, there's a fact dispute here and there. No, we don't owe a duty to a person that is unaffiliated with this bank. And that was dispositive of that. But what they want to do is regenerate it and say, no, it's important in terms of money had and received. No, it isn't, because it is undisputed that that happened, and that in no way can be unjust. It can't be unconscionable for us to follow the law and follow the final payment rule. That can't be unconscionable. It can't be unjust. And so I'm trying to get across the point that there is a different analysis associated with the actual claim that was remanded to Judge McBride and going back and trying a normal fact dispute case. He had all the facts. He believed that those facts were undisputed, and he rendered his opinion by balancing the equities, which, with all due respect, I believe he was told to do, and he did.
All right, thank you. Thank you, Mr. Kirkman. Trowbridge, you've saved time for rebuttal. So as Mr. Kirkman has pointed out, you have a pretty steep burden to show that Judge McBride not only made an error, but abused his discretion here. This is normally the sort of latitude that we give to the district judges, even if sitting in their shoes, we might have decided the case differently.
I disagree, Your Honor, and here's why. What's before this court is a summary judgment order. Summary judgment orders are reviewed de novo. There is language in this court's prior opinion that says a court's decision to invoke the doctrine of unclean hands is reviewed for abuse of discretion, but that abuse of discretion standard presupposes that findings of fact have been made. Judge McBride, the district court, was not the finder of fact here. And under an abuse of discretion, an abuse occurs at the district court.
Mr. Trowbridge, can I just clarify what you just said, just to make sure I'm understanding and we're communicating? Once, your view of how this area of the law works is there may be factual disputes, and those are for a fact finder, a jury in this case, unless summary judgment's proper. And the question of whether summary judgment's proper on the fact issues is reviewed de novo. But once a jury finds facts, or perhaps a judge in a bench trial finds facts, or once a judge correctly decides there's no disputed material facts, then the final decision of what equity and good conscience requires is for the judge essentially sitting in equity to decide under an abuse standard.
Yes, that's why the court will see, and this court used that language in the prior opinion, that they review a decision to invoke the doctrine of unclean hands for abuse of discretion. However, that invocation of unclean hands can't take place until facts are tried.
So what factual disputes did the district judge erroneously grant summary judgment on? Is it the date on which the $4.4 million check was deposited, the issue about June 25th? Or was it some other factual dispute?
Your Honor, the court didn't engage, the court, one, they didn't balance the equities. The court did not find that there were undisputed facts. What happened in this case was the court simply picked facts that it liked and didn't even mention facts it didn't like.
Well, but let's refine Judge Barker's very good question, which is you're trying to defeat a summary judgment. Always when a party tries to defeat a summary judgment, the party has to show us what are the disputed, not only disputed issues, but disputed issues of material fact. So what are the issues that are material insofar as it would make a difference to the result?
Yes, the issues that are material, Your Honor, are the balancing of the equities. What is just? What is conscientious here? We outlined in the summary judgment evidence all of the, to use Judge Ho's words, red flags that went off on the bank's side. They outlined in their summary judgment evidence, all of the red flags that went off on the plaintiff's side, on Midwestern Cattle's side. Those are the fact issues that the jury had to weigh. The jury had to balance. The jury had to determine who was credible. The jury had to make those inferences, not Judge McBride here.
The jury decides whether those are in fact red flags.
Yes,
And the judge decides if the jury finds red flags on both sides, the judge then strikes the balance.
yes, Your Honor.
And that last thing is subject to abuse of discretion.
Yes, and I want to clarify something. Mr. Kirkman stated in his argument that the last thing we need is another jury trial on this. I hope this court understands, no jury trial has ever taken place in this matter. The first decision that went up was on summary judgment.
One final question, if I may. What amount of money do you allege Legend has in its possession that rightfully belongs to your client? You have 10 seconds, but what's the number?
Yes, Your Honor. There's a deficit of $4,991,348.36. And the summary judgment evidence that established that was the testimony of MCM's expert Donald Lockaby, which goes to that Legend received $85.4 million from Midwestern Cattle, but Midwestern Cattle only received $80.8 million back.
All right, thank you, Mr. Trowbridge. Your case is under submission. The court will take a very brief recess before hearing the final case.
Thank you, Your Honor.